Hi, it's Natalie from Reeboks HR. I haven't actually jumped on and done a little video for you guys in a little while. I've been super busy since we've come back from Christmas. It has been absolutely bonkers with training requests, and I've been going through with all of our clients all of the changes relating to the Employment Rights Act to make sure that they're compliant. Obviously, that's my job. But one of the other parts is that I've been really training. I've been hosting so much training over the past few weeks. It's insane. So I am doing everything I possibly can to get employers compliant with the Employment Rights Act. So this comes in with effect. Some parts of it have already started coming in already, but we have the main bulk of these or main bulk of this law comes in with effect from April. So in this video, I'm going to be telling you the 10 key policies that everyone should be revamping, reviewing, having a look at, and making sure that they are compliant in preparation, really, for these April changes. So, whilst we could talk about the Act itself, which is a beautiful 289 pages long, this is basically acting as a framework. So the full practical effects will only become clear once we have the relevant regulations, the code of practice, and of course, our updated guidance has been published, which does take quite a long time. So whilst we are aware of what changes are coming, what they look like practically are going to feel quite different to how we've been practicing up to this point. So I'm going to talk about these parts that will be implemented in 2026 and 2027 throughout this video as a little disclaimer. So the first one, the one that everybody keeps talking about and asking me about, is the sickness absence policy. As we know, the Employment Rights Act is making statutory sick pay, or SSP as a lot of our clients call it, a day one right. So this ultimately means that anybody who is earning below the rate of statutory sick pay, then they will be able to qualify for that, and it will be set at 80% of their average weekly earnings. So to update your policies and processes, you have to remove any reference to waiting periods and the lower earnings limit, of course. There's plenty of other bits and pieces that we could go into, but I have just done this as a whistle-stop tour video. The second one that we're going to be talking about is the paternity leave policy. So what's changing with this? Ultimately, the Act is going to be removing the qualifying periods for paternity leave, making it a day one right. So it also provides that the current restriction, it prevents parents from taking paternity leave. If they've already taken shared parental leave, that will also be removed. So any policies that you have has to make sure that any references to the current 26-week qualifying service requirement are then amended so that it's clear that that requirement is no longer there and that it becomes that day one right. The third one that we're talking about is the parental leave policy. So what is actually changing with this? So it's removing the qualifying period of 1 year service to be eligible to take parental leave, making it a day one right. Remember that parental leave is actually a requested period of leave and should not be confused with dependency leave, which is if childcare has let you down, etc., and you've got to collect your child from the setting. So we have to be absolutely clear on what this looks like throughout our family-friendly policies. Another biggie is that we've got the anti-bullying and anti-harassment policy. So we're seeing a lot stronger steps being taken to prevent any form of bullying harassment within workplaces. So this imposes a duty on employers to take all reasonable steps to prevent sexual harassment from occurring in the workplace instead of just reasonable steps. There's a difference in the law from what we've seen with the updates a couple of years ago. So it actually extends not just to sexual harassment, but it does extend to harassment on the grounds of the protected characteristics such as age, disability, race, religion, belief, etc. So we've got quite a lot to update with that. And one of my key pieces here would be to encourage yourselves to undertake, and your managers obviously, to undertake the prevention of sexual harassment training, because banter is not a defence at tribunal, and we are starting to see a significant amount of cases relating to this particular area of law within the tribunal system currently. So do keep an eye on that one. As part of this, you need to make sure your anti-bullying and anti-harassment policies are updated alongside your sexual prevention of sexual harassment at work as well. Number 5 is the varying terms and conditions policy. Now, this is generally used by much larger organisations, and it's commonly referred to as the fire and rehire practices. So this is has been thrown into the spotlight from the P&O Ferries case that we've seen play out, and therefore there are much stronger protections now. So under the Act, a dismissal will be automatically unfair if the reason for the dismissal is because the employee refuses to accept a restricted variation to their contract. So there's a lot to this one, and if anyone wants to have a conversation with me about it, you can pop me a DM, and I'll be more than happy to jump on the phone or have a quick Q&A with you. So again, if you have a policy like that, it needs to be reviewed. Number 6 is our flexible working policy. Now, this is one that is being used quite a lot by organisations, a lot more so in recent years, especially after COVID and people wanting to work from home, amend their hours, etc. So under the Employment Rights Act, the employer will be able to refuse a flexible working request on one of the existing grounds only, but only if it is reasonable to do so. And if they do refuse a request, they must notify the employee for the grounds of refusal and why the refusal is reasonable. It's no good actually just saying to people, we refuse it because it doesn't work for operational reasons. There's a lot more that we have to justify now, so be careful with this one. So what needs to be updated, obviously, is your flexible working policy. And of course, we need to amend it to make sure that it is very clear that a request for flexible working will not be refused by the employer unless it is absolutely reasonable to do so. This is quite a big one, so do get in touch with me if you have any specific questions around this. Also, number 7 is the probations policy. So this is what our clients refer to as the 2-year rule. So what is actually changing with this one is they are removing the qualifying period for claiming unfair dismissal from 2 years to 6 months, which is going to significantly impact, one, how you measure if people are being, are being productive and are performing within that first 6 months. You have just 6 months to determine whether someone is right for your organisation or not. We can read into that, and I'm not going to offer my opinion on it, but it is the one safety net employers do have at the moment. However, from the 1st of July, that is going to change. Whilst it doesn't become law until 2027, we're going to see that qualifier being from the 1st of July 2026. So be careful again with this one. And if you're unsure, let myself or Faye know. We are training people and going to be running plenty of training courses on probations specifically and how to manage those over the coming months. So number 8 is our onboarding policy. So the Act itself changes the qualifying period for claiming that unfair dismissal piece. So that will then be updated as well. So a lot of people will have what that looks like in terms of probations and how they onboard people into their businesses. Actually, if you do have a separate onboarding policy to your probations, then you must have that reviewed as part of this process as well. Number 9 is the redundancy policy. So currently there is a duty to collectively consult when the employer is proposing to dismiss or make redundant 20 or more employees at one place of work within a 90-day period. So therefore, the Act is now requiring you to collectively consult and will also be triggered where a different threshold is met. So whilst this hasn't been identified yet in these regulations, it is likely to involve a calculation across the entire organisation. So this is likely to affect people that have multiple employees, so larger organisations. Again, the piece around this is to update the redundancy policy. And when we have that framework and what that looks like, we will certainly update you on that. And last but not least, we have our bereavement leave policy. So what's changing with this is that there will be a new statutory right to bereavement leave, allowing all employees who's lost a loved one to be able to take that leave from work. So if you have a compassionate leave policy or a bereavement leave policy, then those will need to be updated as well. But that is coming in 2027. So I know this has been a lot, so thank you for sticking with me through this video today. I hope that you find it helpful. Faye and I are here to answer any questions that you may have around the Employment Rights Act. If you want specific training for you, your teams, or your organisation as a whole, do get in touch with us. Faye and I are doing lots of management masterclasses so that we can equip you as much as we possibly can before the new legislation does take effect. As I said, thank you for sticking with me. I know this hasn't been a short video, but thank you very much for listening, and I will see you in the next one.